It begins in a place that is supposed to be boring. An elections office in Union City, Georgia, the kind of building that exists to be unnoticed. Desks, filing cabinets, boxes, paperwork that only matters when it matters most. On this day, it mattered. Federal agents from the FBI arrived with a search warrant, court-authorized, specific, directed at records tied to the 2020 U.S. presidential election, ballots, related materials, the physical remnants of a process that 4 years later is still being examined. There was no announcement beforehand, no press conference, no flashing lights meant for spectacle. Just federal law enforcement executing a legal order. And yet, this was not routine. Because this was Fulton County, and because this search did not happen quietly. The FBI described the action with careful language. A court-authorized law enforcement activity. That phrase is deliberate. It is meant to say everything while revealing almost nothing. Officials declined to explain further, citing an ongoing investigation. That silence is part of the sound of this moment. Local officials, meanwhile, were left reacting in real time. Concerned, alarmed, asking questions about what was taken and why. This was not the first time federal authorities sought access to these records. The Justice Department has previously sued for access to the materials now being seized. That matters, because it tells us this is not a sudden interest. This is not a spur-of-the-moment decision. This is the continuation of something already underway. You know, there is a particular feeling when the federal government shows up with boxes. It changes the air in the room. What happened here was not an accusation. It was not a conclusion. It was a step. A procedural step, yes, but one with weight. Because election records are not just paper. They are the documentation of a civic act. They are guarded, logged, preserved, and when they are removed, even legally, it signals something important is happening. The FBI does not execute search warrants lightly, especially not in places tied to elections, especially not when the investigation is still active. Local officials expressed concern about the seizure of materials. Concern is the polite word. Because when ballots leave the building under federal authority, people want to know where they are going, how long they will be gone, and what happens next. Those questions did not receive answers that day. And then there was something else. Something that made this moment unusual, even by federal investigation standards. At the site of the operation, observers saw the U.S. Director of National Intelligence, Tulsi Gabbard, seen on site, present during a domestic law enforcement action. That is not typical. The Director of National Intelligence oversees the intelligence community. That role is not usually visible at an FBI search in a county elections office. This was noticed, quietly at first, then more loudly. Because appearances matter. And this appearance raised eyebrows inside and outside government. No explanation was offered for why the Director of National Intelligence was there. No comment on whether her presence was supervisory, observational, or symbolic. Just the fact of it. Sometimes the most striking part of an event is not what is said, but who shows up. Sometimes the silence is the loudest part. The FBI maintained its limited statement. Court-authorized, ongoing investigation, nothing more. The Justice Department, which has previously gone to court to gain access to these same records, also offered no new details. This is how investigations move when they are still alive. They move without narration. But the context here is unavoidable. The 2020 election remains the subject of multiple legal and federal inquiries. Records from that election are evidence, history, and legal material all at once. Fulton County has been central to that attention. And now, the physical records themselves have been taken into federal custody. Not all of them, not necessarily permanently, but enough to matter. Local officials were not accused of wrongdoing in this action. No charges were announced. No individuals were named as targets. This was about documents. But documents are never just documents. They are proof of what happened. They are the answer to questions that have not yet been fully asked in public. And when the federal government seeks them again, after already suing for access, it suggests persistence. It suggests unresolved issues. It suggests that whatever this inquiry is examining, it is not finished. There is a careful restraint in how this has been described by authorities. That restraint is intentional. It protects the investigation. It also leaves space for unease. Because in a democracy, elections are the foundation. And when that foundation is still being examined years later, the process itself becomes part of the national conversation. Not through speeches, not through commentary, but through sealed warrants and quiet removals. Paper can carry a lot of weight. At the end of the day, the office in Union City closed like any other. The desks remained. The building stood. But some of the materials inside were gone, and the people who worked there were left waiting for answers that did not come. This was not the end of anything. It was the continuation of something already in motion. And that motion, for now, is moving forward without explanation. What we know next is defined almost entirely by what officials did not say. The FBI executed the warrant. That much is clear. They went into the Fulton County Elections Office in Union City, Georgia, and seized records tied to the 2020 U.S. presidential election. Ballots and related materials, physical items, not summaries, not copies, actual records. That detail matters, because physical custody is different from access. This was not a request. It was not a negotiation. It was a search, and it was authorized by a court. The phrase court-authorized law enforcement activity is not casual language. It is a legal boundary line. It means the FBI believed it met the standard required to go before a judge and receive permission to enter the building and take possession of materials. That threshold is not low, but beyond that phrase, nothing more was offered. No description of scope, no timeline, no explanation of what prompted the action now, and no indication of when, or if, the materials will be returned. Local officials were left to respond after the fact. They expressed concern about the seizure, concern not framed as resistance, but as uncertainty. Because when election materials are removed from local custody, even temporarily, it raises administrative, legal, and public trust questions. Those questions are not theoretical. Election offices are governed by strict rules about chain of custody, retention, and access. When federal agents intervene, it changes the responsibility map. Who is accountable for those records while they are gone? Who answers if questions arise? Those are not abstract worries. They are operational realities. This was not the first interaction between federal authorities and these records. The Justice Department has previously sued for access to them. That lawsuit is an important piece of context because it shows a pattern. Federal interest in these materials did not begin with this search. It escalated to litigation, and now it has escalated further. The progression is notable because it shows persistence. When access is denied or delayed, the federal government has mechanisms to pursue it. This search warrant is one of them. Still, no accusation has been made publicly. No wrongdoing has been alleged in connection with this specific action. The FBI did not say the records were hidden. They did not say they were altered. They did not say they were destroyed. They said they were seeking them. That distinction is critical. This is about possession, not about claims. But possession itself carries implications, especially in an election context, especially when the election in question is the 2020 U.S. presidential election. The materials sought are not symbolic. They are evidentiary, and evidence is collected when questions remain unresolved. There is another layer to this moment that complicates its reading. The presence of the U.S. Director of National Intelligence, Tulsi Gabbard, seen on site during the execution of the search. This is unusual. The Director of National Intelligence oversees the intelligence community. That role is not typically visible at a domestic law enforcement search conducted by the FBI, especially not at a county elections office. There was no official explanation for her presence, no statement clarifying her role, no indication of whether she was observing, coordinating, or simply present. The lack of explanation makes the appearance itself the fact, and that fact stands out. Because in government, roles are usually carefully separated. Domestic law enforcement is one lane, intelligence oversight is another. When those lanes visibly intersect, it draws attention, not because it implies misconduct, but because it signals significance. Someone at the highest level of the intelligence community thought it was important to be there. And that alone invites questions. Again, No answers were provided. The FBI declined further comment, citing the ongoing investigation. That phrase does a lot of work. It closes doors. It also tells us this inquiry is active. Not dormant. Not concluded. Active. That status matters for how much information can be released and how much must remain sealed. Local officials, meanwhile, were left managing the immediate impact. They were concerned about the seizure of materials. They were not briefed publicly on the scope. They were not told how long the records would be held. They were not told what specific questions the records were meant to answer. This is the asymmetry of federal investigations. One side knows more, the other waits, and the public watches both. There are moments when procedure feels personal. The building itself did not change. The office remained open. The work continued. But the absence of records creates a void, and voids invite interpretation, even when officials are careful not to speculate. This is where restraint becomes visible. The article does not describe protests. It does not describe conflict. It does not describe confrontation. It describes concern. Concern expressed by local officials. Concern rooted in the removal of materials tied to a foundational democratic process. The Justice Department's prior lawsuit is not a footnote here. It is part of the through line. It shows that access to these records has been contested. And when access is contested, escalation follows a predictable path. Requests, then court filings, then enforcement. This is that final step. Still, the FBI's silence is telling in its consistency. No elaboration, no leak, no framing, just the legal minimum. That approach is often used when investigators want the facts to speak for themselves later, not now. And that later has not yet arrived. What we are left with, in this moment, is a sequence of actions. A search warrant executed, records seized, a high-ranking intelligence official present, local officials concerned, federal authorities silent. Each of those facts stands on its own. Together they form a picture of a process still unfolding, not resolving, not closing, unfolding. And the absence of commentary is not accidental. It is part of how the system moves when it is still working through something. The 2020 election remains central to this inquiry, not as a political event, but as a documented process. The materials tied to it are being examined again, handled again, taken again. That repetition is meaningful, but its meaning has not been explained. And until it is, the focus remains on what we can see: federal agents with a warrant, boxes leaving an office, a director present without explanation, and officials who can only say they are concerned. No conclusions were drawn that day, no announcements made, just action, and the understanding that this action fits into a larger legal effort already in progress, one that has not yet reached its endpoint. By the time the federal agents left the building, nothing had been announced. No summary of what was found, no list of what was taken, no explanation for why this step happened now. What remained was the shape of the action itself: an elections office in Union City, Georgia, a search warrant, records tied to the 2020 U.S. presidential election removed under federal authority, and a quiet acknowledgement from the FBI that this was a court-authorized law enforcement activity, followed by a refusal to say anything more. That combination is deliberate. It is the sound of a process still underway. The Justice Department's prior lawsuit for access to these same materials sits in the background of this moment like a timestamp. It confirms continuity. This did not appear out of nowhere. This was not sudden curiosity. This was a continuation of a legal effort that had already reached the courts. When access was contested, the system moved forward. When the system moves forward, it does so incrementally. Requests become filings. Filings become orders. Orders become action. This was action. Local officials who oversee the daily operation of the elections office were left responding to the fact of the seizure rather than its rationale. They expressed concern, not defiance, not refusal, concern. Concern about the materials, concern about their absence, concern about what it means when federal authorities take possession of election records. Those concerns were not accompanied by accusations. No one was accused of wrongdoing in this operation. No individual was named. No allegation was announced. The action focused on records. That narrow focus matters. It tells us what this moment is and what it is not. It is not a conclusion. It is not a verdict. It is not a declaration. It is a step in an ongoing inquiry. And those inquiries, by design, do not narrate themselves in real time. The FBI's decision to offer only the barest description is consistent with that design. Court-authorized, ongoing investigation, nothing further. This language is not cold, it is careful. It preserves the integrity of the process while withholding its destination. What complicates this otherwise procedural moment is the presence of the U.S. Director of National Intelligence, Tulsi Gabbard, at the site during the operation. Seen on site. That fact stands without explanation. There was no statement clarifying her role, no indication of whether she was there as an observer, a coordinator, or in some other capacity. The article does not speculate. It simply reports her presence, and that presence is unusual. The intelligence community and domestic law enforcement operate in adjacent but distinct spaces. When their leaders appear together at a local election office during a federal search, it signals importance without defining it. Sometimes importance is conveyed without words. This was one of those times. The lack of commentary surrounding her appearance mirrors the silence surrounding the search itself. No amplification, no framing, just the fact. That restraint is striking, because in many moments involving elections and federal action, commentary rushes in to fill the gaps. Here, the gaps remain. And that, too, is information. What is left behind after the agents depart is not clarity, it is awareness. Awareness that the 2020 election continues to be examined through its physical records. Awareness that those records are still moving through legal channels. Awareness that federal interest in them has not diminished. And awareness that this inquiry is active enough to justify escalation. The elections office itself remains. Its staff continues their work. But the removal of materials changes the environment. Records are not passive objects. They are responsibility, they are reference, they are accountability. When they are gone, even temporarily, the question of stewardship becomes central. Who holds them? Who safeguards them? Who answers for them? Those questions now sit with federal authorities, at least for now. The article does not say how long the materials will be held. It does not say when they might be returned. It does not say what specific questions they are meant to resolve. That absence is not a failure of reporting. It is a reflection of how little has been disclosed. The Justice Department's earlier lawsuit underscores that disclosure has been a point of tension. Access to these records has been contested. That contest has now moved beyond court filings into physical custody. This is the furthest point in that progression so far. What happens next is not described. There is no timeline offered, no next step announced. Just the understanding that this was not an endpoint. The FBI did not say the investigation was nearing completion. They did not say it was expanding. They said it was ongoing. That single word carries weight. It means the questions that prompted this action have not yet been fully answered. It means the materials seized are still needed. It means the process is still active. And that matters in a system built on procedure. Sometimes the work continues long after the headlines fade. This moment did not arrive with spectacle. It did not leave with resolution. It sits in between. Between what has already happened and what has not yet been revealed. Between local administration and federal authority. Between access sought and access obtained. The presence of the Director of National Intelligence remains unexplained. The concern of local officials remains unresolved. The contents of the seized materials remain undisclosed. Each of those facts stands unchanged at the end of this account. And that is the point. This is not a moment designed for closure. It is a moment designed for record-keeping, for evidence gathering, for procedural movement. The elections office in Union City became briefly a junction point for those processes. Not because of what was said there, but because of what was taken from there, and because of who was present while it happened. The system, as it appears here, is quiet, it is methodical, it is slow, and it is still moving. No conclusions were announced, no implications were drawn. Just a search, authorized by a court, executed by federal agents, observed by a senior intelligence official, and met with concern by local administrators. Those are the facts as presented. They stand on their own, and they mark a moment that is not finished yet.